as with a lot of areas of the law, invariably what happens in relation to trust instruments is that it's not a problem until it becomes a problem. And when it becomes a problem, it's generally because of some relatively aggressive or disgruntled or upset third party. So I'm particularly thinking about banks, financial institutions, the tax office, any revenue authority, duties office included, or disgruntled beneficiaries, whether they be former spouses or children that are wanting to have a shot at the title. The non-existence of a trust instrument in that style of situation is generally what bubbles this stuff to the surface. And this one was an example of a financier wanting to be very particular and possibly overly pedantic, but at the end of the day, they had the money and the golden rule applied. We did in fact have an original trust instrument here, and the trust instrument was from 1980 something. And what happened though is, in relation to the original trust instrument, there was a space on the front page for the date, left completely blank. And no one had realised that over the last 30 years, that they'd been walking around with the only copy of the original deed and the date had never been inserted. Interestingly though, the Stamps Office at the time, and there was an obligation to stamp the document back in the 1980s, most jurisdictions have abolished that now. In saying that, I know both Victoria and New South Wales still have a nominal $500 style fee that's imposed, but many other states have actually abolished the need to stamp an original trust instrument. That trust instrument was stamped in early 1984. And when I say early, I'm talking like the 9th of January or something in 1984, but the date there was actually blank. Interestingly, and this goes to one of those earlier comments about, the trust instrument is a really broad concept. Do not just think about the deed itself. Someone over the years had produced a certified copy of the trust instrument, and that certified copy of the trust instrument had the date listed as 28th of the 12th, 1980, but the photocopier missed out the very last number. So with all of these case studies, you can't actually make this stuff up. How on earth they ended up with a certified copy that was dated off the back of an uncertified original that was undated, I don't know. How they then managed to use a photocopying machine that photocopied everything perfectly, including that imprint stamp that was sitting over here on the certified copy as well, but then managed to have the page not wide enough to miss out the missing date, was unbelievable. And in the context of that factual scenario, the financier was refusing to lend any money. This is in 2015. What we were able to do, and there's no case law on this, and I don't know what would happen if it ever did go to the courts, what we were able to do was produce a third instrument, and we innovatively titled this a deed of clarification. So deed of clarification. And under that document, there was a whole range of self-serving statements, the main one being annexing I think what the IT people call a stitched document or a merged document that merged the certified copies together, inserted the date, and then clarified that missing number there must have been 3. Must have been 3, because we had a January 1984 date on the Stamps Duties Office, independent third party had confirmed that, and we knew that the certified copy was the 28th of December 1980 something. So our best guess was that must have been 1983. And there were bank accounts that were set up at around that time. There was property that had been acquired at around that time. So we were relatively confident that that was the missing date. What we were not so confident about was whether this sort of self-serving deed of clarification in 2015 was going to be enough to get the bank lawyers across the line. It was. Luckily for the client and luckily for us, it was enough, and the bank were willing to proceed with the refinance based off the back of that deed of clarification.